Okay. So this is coming from some work that we had started in 2023, and we've now repeated it, but we found it useful to bring out one small piece of insight from this work. We titling this "Get Them to Court on Time" to try and where are the bumps in the road to justice. Okay. So the context of our court system is well known to all of us. We've got about 4.6 crore pending cases, 3.5 crore criminal, some 1 crore civil. And there's a lot of clamor that, look, delays are happening and justice delayed is justice denied. Now, in terms of the solutions to try and fix our legal system, you can see this in the allocation of 7,000 crores to the e-courts project, or you can look at everything. Every time a senior judge has some suggestions, it's usually hire more judges, build special courts, which is the tribunalization of justice, adopt new technology. Today, for example, e-filing has been rolled out in almost all the district courts, and, rewrite procedures. I think in 2024, the BNSS replaced the CRPC, and all of these are the suggestions that are being talked about. What we think is that these are solutions in search of a problem, and the problem is poorly understood. It's a well-known fact that, if you really want to solve a process, you need to understand the depth of it and understand where time is being spent, what are the bottlenecks. And if we wander blind to apply solutions when the problems are unclear, it will hurt us. The reason is that any kind of reform takes a lot of resources, not just people, money, and time, which is, but also political capital. We've seen this in some of our conversations with judges that any kind of reform attempted at a district court or a high court usually brings with it a lot of protest, a lot of resistance to change. And we must really think about whether the solutions that are being proposed will actually solve the problem. A lot of people are very happy to, take some amount of difficulty in adapting to a solution as long as it solves the problem. And our contention is that we need to really articulate what the problem and what the solution is before you go ahead. So we ask the question, where are cases stuck? And we argue that without understanding the life cycle, you're really going to be groping in the dark for the right kind of solutions. So what do? We know, the lawyers know that there are different stages that a case goes through. So there is a filing stage, at which point of time somebody from the court scrutinizes the case and checks, are you genuinely a party to this case in terms of, is your name right? Do you have an ID? Are you filing it in the right jurisdiction? Some basic checks are done, which is called the scrutiny process, at least in the district court. Then there's an admission process. Somebody has to say that, yeah, this is a legitimate case. In the case of criminal cases, there is an entire process called taking cognizance of something. In criminal cases, typically, because the case is filed by the state or by a private person, you need to get the accused to court. So there is sometimes a summons process followed by a warrants process, bailable and non-bailable. And in civil cases, well, if you file a case and you sue somebody, the other party has to turn up. Sorry, ignore the typo there. That's bail and plea, not bail and pleas. Oh my God. But there is a bail process in criminal cases. And then in civil cases, when the respondent appears, typically both parties are expected to file some written statements. The judge looks at both sides and says, okay, this is the issue that we're going to discuss, after which it moves on to evidence, arguments, and judgments. Now, at each stage of this process, what is actually needed is different. So the resources that they consume, often the judge isn't, I'll tell you the answer to what we're saying is that we don't think the judge is actually required in a lot of these steps. And we also recognize that each of these steps takes different amounts of time, and the coordination between different actors is needed. So just throwing more judges at the problem may not solve anything. We really need to go double click into this and understand what is working. So targeted interventions require you to have some specific understanding of what aspect of the stage are you shortening. So for example, now that e-filing is now the norm in district courts, what's happened is every case now needs to be filed online as well. But after that, the file the digital file is almost never used. Almost in all our interactions speaking to lawyers, they tell us convincingly that in district court, it's still the docket, the physical docket. Maybe some high courts have moved on. I've heard good things about Delhi. But the broad condition of the court is that e-filing is present, but it's not really used in the later stages. So what you've done by introducing e-filing is the lawyer now not only has to create the physical file, they also have to scan the file. So you've added some effort. And the scrutiny person, earlier, they just had to check that the physical docket was fine. Now they also have to ensure that the physical docket matches the digital docket. And whether this has actually helped in case evaluation or case progression, at least the lawyers we speak to remain unconvinced, and so do I. So if you're going to spend a lot of effort and time in shoving down reform across different parts of the country, we think it's better that there is some kind of result that comes, or you will spend a lot of political capital and you may not be able to repeat such experiments. So what did we do? In the last 2 years, we've kind of been looking at check bouncing cases and motor accident cases. And these are believed to be voluminous enough to the extent of 10 to 15% of the workload. Though our data recording system in NJDG doesn't lend itself to this kind of analysis, we've triangulated it and we believe this is roughly the figure. So what we did, we just looked at about 200 disposed cases that are done through their life cycle in court. We sampled them randomly from the eCodes database. We didn't follow a specific state-wise methodology. We looked at some states, found the data was bad, moved on to other states. So it was random. We covered about 7 cases. And then out of these 200 cases, we removed cases that were transferred. Or in some cases, like in Delhi, in hit and run cases, because there is no accused, there is no trial. So you just close it and the victim gets some money from the state. So we removed all of those. We landed up with about 147 cases, 77 in check bouncing and 70 for motor vehicles. For the non-lawyers or just for anybody else, check bouncing is a crime in this country. So if you give somebody a check and when they deposit the check isn't honored either because there's no money in the bank, or if you put a stop payment. In either scenario, it is a crime. They can take that check, they can take that receipt from the bank that said the check bounced, and you can, be taken to a criminal court. This is a magistrate's court in almost every jurisdiction. Almost every jurisdiction. Motor accidents claims happen. This is third-party motor vehicle insurance related. So let us say I hit somebody, my car hit somebody. Whether it is property, injury or death, either the victim or their family has the right to claim compensation from me. If I have insurance, my insurance provider also gets part of the case. So these are third-party claims. And they go through something called the Motor Accidents Claims Tribunal. This was set up in order to fast-track motor accidents claims because there is a victim and money needs to be given. And there are a lot of laws that they've put in place to try and speed them up. But we see that it's actually not all that fast. So in these 147 cases, we tagged each of the orders. So on eCourts, when you open eCourts and click on a case, you get all the hearings for the case. And we're able to read the business text and identify what stage it is. So we classify these into stages of, for civil, on the LHS is actually criminal. So it should be complaint, then summons, then the warrant, then the bail and the plea and trial and arguments. And on the civil side, there's an appearance stage, written statements, framing of issues. We found it useful to just tag these as pre-trial and trial to try and make a stronger point, though our data has this cut by stage. What we do then is, because every hearing has a date, so we just subtract the time between this hearing and the previous one, and that is the time spent in stage. And we define, not just we, but the broad understanding is that trial begins once both sides of the litigation are present. And that's the stage of trial. What we try and evaluate is what happens to these cases, right? As they progress through the different stages, you will see drop-offs happening. So on the left-hand side is what happens to motor vehicles cases, that only 54% of the cases actually never get to trial. They're disposed of before trial for various reasons. But broadly, if you consider the fact that the motor accidents case is a settlement between the insurance company and the victim or their family, it is kind of understandable that people don't necessarily want to go through the full process. In several cases, the case is disposed of because people did not show up, or they'll move it to the long pending register if somebody is found absconding. That happens in check bouncing cases often, that they've issued a summons, they've issued a warrant, and people haven't turned up. In check bouncing cases, it's 70%, right? 70% of cases never make it to trial. And this also makes sense. In a previous blog, at least in Bombay, we found out that about 50 to 55% of check bouncing cases in Bombay were filed by financial institutions because the check is not really a mode of payment today, it's a mode of credit. So when you want to take a loan or enter into a transaction and you're not good for it in liquid cash, or if it's a payment that you intend to make on delivery, a check is often used as a security deposit or a collateral, with the understanding that if something does not happen, that check will be deposited. And it is a good way to ensure that people pay you, because even if you don't turn up to a civil case for breach of contract violation, the police will come after you in a check bouncing case, and eventually you will be dragged to court. So this kind of also makes sense to us, that a lot of cases are just disposed of before trial. And what we did then was we actually checked, okay, how much time, right, to try and give us a sense of this. We find that for motor accidents cases, a case that 9.5 months is the time. So if you recall, we just divided these stages as pre-trial and trial. And we see that a motor accidents case, they wait for about 9 months, and then the trial takes place in about 4 months. And in check bouncing cases, it takes about 12 months of waiting, and the trial gets done in 3.5 months. Obviously, the trial number is only for the cases that do come to trial. So what we understand is that a lot of effort goes just in getting parties to court. And in check bouncing cases, it's usually through summons and warrants and waiting. And in MACT, we're a bit puzzled as to why this happens, given that a lot of, from what we understand in motor vehicles claims, it is the insurance company who's expected to pay. And even though the driver may be at fault, there is a principle of pay and recover, where they expect the insurance company to pay the victim. And then, the insurance company is free to carry on litigation with the driver or owner if they feel that, this did not warrant an insurance, like if the insurance was expired, or in some cases where they don't think it's the insurance company's fault at all. But either way, we see them waiting. And once parties appear, we see that it's a process of 3 to 4 months. We actually had another slide on the number of hearings. And the trial is again like 2 to 3 hearings, because hearings are separated by about 2 months in these district courts. So the bulk of the effort is actually just waiting. Now, NJDG kind of tells us this as well. So you can look at the district court website of the NJDG, and apologies for that granulation in the pixelation in the diagram. But if you actually make the effort of counting and grouping all of the different categories, we find that 72% of the cases which are pending are at the pre-trial stage. So 48% roughly at appearance, and 14% at summons and warrants, and the rest will probably be that witness examination, where my mouse is hovering. But what we find useful is that while NJDG only tells us the volume of cases and where they're stuck, we believe it's also useful to identify how long are they stuck for. So for example, every time you file a case, it will get pending at the admission or scrutiny stage, but that's not really relevant if you progress beyond that stage in about 3 days or a week. Similarly, if you were stuck at the summons process, but the summons takes a month, that's reasonable. If it takes about a year, then maybe it tells you areas where you need to focus on. This really helped us, because in the traditional mental model of court that we have, what you really imagine is that there's a full day of hearings. Judges are, stacked with matters. Most matters are never heard because of paucity of time. And, there are 50 cases scheduled, and, only 10 get heard and the rest get adjourned. And that we expect judges to be determining complex legal matters. We say objection, my lord, because this might be true of the High Court. But at least in district court, for the sample of cases that we looked at, and we also made visits to district court for these two matters, about 100 to 150 matters are listed daily, and most of them are adjournments. So we find almost consistently, and we've also verified this by speaking to some district court judges, court starts at 11. 11 to 1 is roll call because most of the people have not turned up. A new date is given. And for the few parties where everybody is here and ready to proceed, they say, okay, come back after lunch, and then we will deal with evidence and arguments and any of those. So attendance attendance is what takes up 1 to 1.5 hours. And the courts in the afternoon are actually quite empty, district courts at least. For MACT and check bouncing, we haven't seen other courts in as much depth. Now, we understand this a little bit. There is a paradox of procedural protections, as we say, because check bouncing is a crime, so the accused must be present. You cannot really send someone to jail without them having the right to defend themselves. So the accused has a strong incentive to delay, because in check bouncing, the moment you pay back the check, the case ends. So what you're really buying is time. So think of the check as a loan and that you need to pay back. And what you really want is an interest-free time amount to try and get the money somehow. By the time, it's a race between, will the police come and drag me to court, or can I conjure up the money and just end the case? So in some ways, procedural safeguards are now tools of delay because you can't really proceed and you have to go through the summons and warrants process. Civil matters, we don't as much understand why judges wait. In very few cases, we have seen them move ex parte, but it's rare. It's usually after giving like 3-4 chances to the driver and owner to appear that they move ex parte. CPC also suggests that beyond 3 adjournments, you should just move on, but we've rarely seen that behavior. We have now done this kind of exercise in multiple cases as to understand what is the percentage of cases that get resolved pre-trial. So for check bouncing, we've studied Kollam, that's 54%, Thrissur was 81%, Kochi was 80%, Chandigarh was 85%. And surprisingly, in Chandigarh, 40% of the cases were, we only did 100 cases, so I just want to tell you that we've taken small sample sizes in each of them. And in Chandigarh, in 40% of the cases, the victim was declared absconding and they just gave up. But the interesting thing is they gave up after a year of trying really hard to find them. In Bangalore, surprisingly, it was only 30%. And one possible reason is that in Bangalore, summons is also done by the police sometimes. So it's perhaps speedens up the act of getting them to court. We don't know as much. We did the same thing in motor vehicles. In Kochi, it's 40%, and Bangalore, 27%. So not as stark, but still something that helps us understand that our mental model of courts as a place where judges are hearing arguments, weighing evidence, and delivering verdicts, that's only one part of the system. The court's actually 2 systems. There's an arduous aspect of the administrative elements of filing, scrutiny, scheduling, which is just getting hearings and going through the summons process. Often what happens is the court will not send the summons on time. Then it goes through a post office. So the post office, you have to wait for the post office to come and give you back a receipt. Often that may be misplaced. It may not be tracked properly. Lawyers have to go through a lot of effort to just close the summons process and then move to warrants. In warrants also, we've seen sometimes the police officer may not turn up to court to give a report that I can't find them. We've seen show cause notices being sent in the hearings to SHOs, superintendent something, and to just try and get them to come and give an update. So there's a lot of time. That time between the time in pre-trial, there's a lot of effort just getting people to come to court. We call this the seen and the unseen at play. And we think that, just by adding more judges, you're not really going to solve issues like these, or by, simple technological interventions. Like, okay, virtual hearings can save you the trouble of coming to court, but when not turning up is in the incentive of the people, is that really going to change anything? So what we think we need is you need to build administrative excellence, and you need to separate court administration from judicial functions. And our first talk in the Indian legal systems reform seminar series was by Ajay on the ICTS, the idea of an Indian courts and tribunal service that would help separate out the administrative and the judicial. And we think that there are other ideas that may or may not help. People are playing around with the idea of digital summons, but again, in criminal cases, how do you confirm that it has been delivered? So the summons rules for physical are very clear. It needs to be delivered to a male member of the family, etc. In the case of individuals. In the case of companies, you can leave it at their registered office. But in the case of individuals against whom check bouncing is usually filed, will a digital summons help? Perhaps I doubt, because there was also a recent ITAT ruling, or I think an overruling of an ITAT ruling, where they said that, look, if the income tax sent you a notice and it went to your spam, you can't really move ex parte. You can't really go ahead. You have to ensure that the person has read the request to come to court, etc. So I don't know if digital is really the answer, but perhaps we can think. There is an interesting play in court and police integration, because often the police is understaffed and expecting them to come to court is painful. So just sharing the status of the warrants. There is an experiment with stuff like e-post, where today a person needs to take the physical thing, go all the way to the house, and instead, if you can send a scanned copy to the nearest post office, then you can check the location, because every post office is about less than a day away from any distance. So you can get a response back in a very short period of time. So if you can reduce that turnaround time, perhaps that's something to think about. Private couriers are allowed. They're not being used as widely as they should, perhaps. The USA has process servers where the process server is incentivized to find the accused, and maybe that can help. These are all just ideas. They all need to be explored, and we shouldn't be casual about suggesting any of them. But these have all been bandied about, and I think we should study whether they could work in certain types of cases. Finally, even today, judges have the ability to impose penalties for non-appearance or delays. They really don't. So if we can have stricter scheduling norms and some kind of penalties, maybe that's one way forward, because often, even in a check bouncing case, the accused's lawyer may turn up sometimes, but the accused may not. And, this is really confusing as to, should they be move ahead? Should they wait? And you see in orders, you keep seeing the terms last chance. But the last chance really continues for about 4 hearings. And if hearings are interspersed at 2 weeks intervals, that's like that's about 2-3 months. 2 months, 4 hearings, 8 months just spent waiting. Now, this is just one piece of the puzzle. Some of our other work that we hope to consolidate and share is try and understand why there is a delay. So we have a term called non-substantive, which is broadly adjournment plus, which is that if you do an adjournment, or if both parties appear but nothing really happens, and the case doesn't progress towards resolution, so people ask for more time, or broadly nothing really changes in the status of the case, we term it non-substantive. And across our work on district courts, we find that this number is roughly 70 to 80% across courts. The attribution is actually the court is to blame often because of holidays and, last minute cancellations. This is not to blame them. Judges are overburdened, but I mean that they have a lot of responsibilities, and there's no real cost to rescheduling, because everybody is fine with it. And it becomes the norm that sometimes the court is not available, sometimes the petitioner's lawyer, sometimes the respondent's lawyer. The respondent obviously has an incentive not to turn up. But often we find out that petitioners also delay processes. You will see the term steps not taken in hearing in orders. And they had to do some payment. They had to go give a physical envelope. They forgot to attach the right amount of stamps. And all of these add delays. Sometimes they don't file the wakalatnama on time. There are multiple reasons why things get delayed. And unless you really double click into stage-wise reasons, I think some of these broader ideas may not work. We're curious to understand whether this translates across other case types. I think check bouncing is not really a criminal case in its behavior. It's like a pseudo-civil case. So whether this really applies to criminal cases where it's state versus accused, this obviously may not, because the accused is usually in prison, the whole under trial problem. So who is delaying the case in criminal cases, I think we should study, and at what stage. So for example, we've heard anecdotally that charge sheets aren't filed, so the case can't really proceed. So you don't know what the charges against these people are. So where is the bottleneck? But we think that the bottleneck evaluation, or the approach to bottleneck analysis for life cycle of cases is critical. Finally, BNSS has thrown, at least for criminal cases, a few more spanners. There's now a section 223 that states that you can't even take cognizance without issuing a notice, and a notice is broadly like a summons. So district courts are evaluating how long should we wait after the notice to move ahead. Now there is also a trial in absentia, but for serious offenses, whether this will get used. It probably shouldn't, because it violates some principles, but we should see whether judges use these tools. Finally, we think this one contribution. We broadly think that there is a utility in having an operations view of the legal system, identifying actors, identifying stages, identifying bottlenecks, identifying the reasons, and then double clicking into what are the incentives at play that exacerbate some of these delays, because otherwise people will continue to throw resources at the problem, and all will happen is that we'll all get frustrated by not seeing things move. So that's our contribution, and thank you.